I'm Nick Brooks, a California constitutional attorney. In this video, I'm looking at President Trump's claim that he can cancel all of President Biden's Autopen signed orders. The core questions are simple. Does the Autopen matter legally? And what power does a sitting president actually have to revoke a predecessor's executive orders? Multiple news agencies have reported that President Trump said that any document that President Biden signed with an Autopen is hereby terminated and of no further force or effect, and that the people operating the Autopen acted illegally. In other words, he is treating the use of the Autopen as a defect that supposedly voids those orders from the start. First, what is an executive order? Well, an executive order is an instruction from the president to the executive branch about how to use the powers of the law already given to the executive. It is not a statute. A later president can generally revoke, change, or replace a prior executive order, unless a specific statute or the Constitution itself limits that move. Presidents from both parties have used autopens for years, including for bills and other important documents. In 2005, the Justice Department under President George Bush concluded that a president may legally use an autopen to sign bills into law, so long as the president has approved the content. That logic applies, at least strongly, to internal executive orders. From a legal perspective, the critical question is whether the document reflects the president's decision and authorization, not whether he physically moved the pen. If President Biden directed that an order be issued and used an autopen to sign it, the order is still his. A later president's power to revoke it is the same as if it were signed by hand. President Trump can clearly revoke or replace President Biden's executive orders. He has already rolled back dozens through his own signed directives, which is the standard practice for a new administration. What is unusual is the claim that the autopen itself is what makes President Biden's orders illegal. That runs against DOJ's prior view and against long-standing presidential practice. The more serious legal issues here are about scope and implementation, not the autopen. For example, does a broad statement on social media count as a legally effective revocation? Or do agencies need specific, properly issued orders that identify which previous presidential directives are being rescinded? And when a Biden order implemented or interpreted a statute, any rollback can be challenged under ordinary statutory and administrative law principles. Politically, framing this around the autopen feeds into arguments about President Biden's capacity and staff overreach. House Republicans have criticized his use of the autopen, but did not produce clear evidence of a covert scheme to sign orders without his knowledge. Legally, though, the foundation remains that autopens have been treated as valid tools when used under presidential direction, and the power to revoke executive orders comes from Article 2 and statute, not from attacking the device used to sign the orders. So, yes, the key legal point is that presidents can revoke prior executive orders, and the autopen does not, by itself, change that authority. What matters going forward is which Biden orders President Trump actually rescinds in a valid new directive, and how those reversals hold up when measured against the statutes, the Constitution, and possible court challenges. If you like this information, please visit my website at nickbrooksesq.com. That's nickbrooksesq.com. And also, please subscribe to my YouTube channel for more constitutional law tips. Thank you very much.